Welcome, and thank you all for joining us today for our Landlord Learning Series. I am Ayanna Pointer, Housing Choice Voucher Landlord Liaison, and I'll be your moderator today. The City of Norfolk Department of Neighborhood Services and Norfolk Redevelopment and Housing Authority have teamed up to help promote the Rent Ready Norfolk program and the Housing Choice Voucher program. These programs are essential to tackle our main objective, to create more affordable housing stock in Norfolk. The Landlord Learning Series is designed to empower landlords with the information to make informed decisions. We will be hosting monthly sessions on a range of topics. Today's session is about legislative updates that impact landlords. Today we'll hear from Ms. Christie Marra, attorney with Virginia Poverty Law Center. First, I would like to go over some housekeeping items. Please hold your question until after the presentation today. In the meantime, you can add your questions to the question box and they will be addressed at the end of the session. Also, a copy of the presentation is in the handout section on your display screen. At the end of the session today, a survey will be emailed to you from GoToWebinar. We would like your input to improve these webinar series and also to learn more educational topics you'll like to hear about. So without further ado, I would like to introduce Ms. Christie Marra. Ms. Marra, thanks for joining us today, and the floor is yours.
Thank you so much, and it's my pleasure. And hopefully everybody can see me and see my screen, and I can't see anyone, so please, if somebody will just interrupt me if that is not the case. But I understand that as we go along, some of you may raise your hand, and I'm happy to answer questions then. I'm also going to really look forward to the questions that come at the end of the presentation. So just a little bit about me and my organization. I am a longtime legal aid attorney. For the past 17 years, I have worked at the Virginia Poverty Law Center, and we provide training to lawyers and non-lawyers alike across the state on civil legal issues that impact people who are low income. We also do legislative advocacy, we do litigation, and we do a lot of community education and one-on-one advising of people on the law. We run what's called the Eviction Legal Helpline for any tenant in the state who is facing eviction. And I know you all are on the other side of that equation, and I'm so pleased to be speaking with a group of housing providers this morning. I think you all will have some really interesting questions, and I hope later in the hour we'll be able to really get into some interesting issues in our discussion. But the slides that I will go through now really focus on something that I think has been incredibly confusing for many people, and that is what rules that have come about to help landlords and tenants during this pandemic will be permanent, and what rules that have been enacted during the pandemic are going to end soon. And so that's really the purpose of this. So let's get started. Let's try to get started. Here we go. That's us. So as I said, we do advocacy, education, and litigation. So as you all will recall, when the pandemic first hit in the spring of 2020, one of the, as businesses shut down and everybody was inside, many people not working at all, there was real panic, widespread panic about evictions. And we here in Virginia were very fortunate that the advocacy community, the landlord community, and the state government came together to figure out the best way to help tenants stay housed and help landlords pay their bills and their mortgages. And this was even before the federal rent relief. We were able to, well, this actually came into place after the federal rent relief came into place. So this rule that I'm talking about now went into effect March 1st of 2021. So as you know, the federal rent relief became available, I think it might have been that very same month. And so under that rule, which is in effect until this July 1st, So we have about 3.5 more months of this being the law of the land here in Virginia. If a tenant has not paid their rent on time, the notice that must be provided to them has to do the following. Number one, it has to tell them that they have 14 days to pay their rent in full. And if they don't pay their rent in full within 14 days, they could be evicted, taken to court and evicted. But it also has to tell them that the Virginia Rent Relief Program can pay their rent for them, and has to tell them how to apply, or at least provide the phone number for and the website for the Virginia Rent Relief Program. And then, and this is really the most important part, the notice has to tell the tenant that if they haven't applied for rent relief, and if they don't, unless they tell their landlord that they have already applied for the rent relief, the landlord must and will put in an application for rent relief on behalf of the tenant. And the tenant is obligated to cooperate with the landlord. There's been a lot of confusion about what that term cooperation means. I do not think that a tenant failing to initiate contact with the landlord after receiving a notice will always be seen as a lack of cooperation. I think the best practice is, if you have not heard from your tenant within a few days of issuing that 14-day pay or quit notice, maybe give them 5 days or so, a follow-up notice or phone call that expressly says, hey, do you want me to apply for rent relief on your behalf? And that would be a sufficient way to determine whether or not they are cooperating. If they don't respond to that very specific question, I think you have grounds for non-cooperation. Why is that important? Because unless you do all these things, you cannot move to evict your tenant. You can file a case, but it will be dismissed, should be dismissed, unless you can show that the tenant did not cooperate. So that's why that's important. Now, I think we all agree that the best course of action is for everyone to cooperate, for the tenant's application to be filed, and for the payment to be made to you all, so that you can remain economically viable. So that obviously is what everybody wants. But I did want to go over the situation in terms of a non-cooperating tenant. The other circumstance under which you could bring an action to put your tenant out is if 45 days after the application for rent relief is complete, meaning all of the documentation has been filed with the rent relief provider, with DHCD, the Department of Housing and Community Development, by you and by your tenant. If 45 days after all of that has been filed, the payment still hasn't been made, then you would be able to make a motion to move forward with filing an eviction case. We don't think that's the best course of action, but that is the law. We think, and we encourage people, both landlords and tenants, to get as much help as possible in filing for this. And again, you only have the option, well, let me put it another way, you only have the obligation to file until July 1st. We are hopeful that the federal rent relief that Virginia has will not run out until late summer, early fall. So if there is still money available after July 1st, by all means, you should apply for it. I would suspect, and I know that there have been significant delays lately in getting this money. We are all frustrated by that. I would suspect that after the mandate goes away on July 1st, it will be quicker. So I would encourage you all, being the ones in the know, I would encourage you all to continue to submit those applications on behalf of tenants who need it. Everybody would much rather see everybody get paid, and paid quickly. All right, I am going to move on to the next. It's very strange for me to do this without having the ability to get questions as I go. So I hope you all are gathering together a lot of good questions for us to have a conversation at the end. Okay, so another set of laws that were enacted to protect tenants and landlords during the pandemic and that expire July 1st of this year are on this slide, right? So that first slide talked about what do you need to put in your notice, right? And there are lots of details that need to go in those notices. Those what we often colloquially call pay or quit notices right now. This talks about what are the actual rights, okay? So until July 1st, tenants have 14 days after they receive that notice to pay their rent. You all will remember that before the pandemic, tenants only had 5 days after they received the notice to pay the rent. And if they hadn't paid by the 6th day, then they were in a position where their landlord could bring an unlawful detainer action, an eviction action in court. That has been extended to 14 days. All of your notices should reflect that. I will tell you a little not so secret, which is that we are working with a legislator who is very committed to keeping it at 14 days. Unfortunately, that bill to keep it at 14 days and make that time period permanent did not pass this year, but we expect it to be back next year. And so I would encourage you to think about keeping, you have the option to give your tenants 14 days. I know a lot of landlords like you all who really care about their tenants will hold off on sending that pay or quit notice for a few weeks and then send the 5-day notice. My opinion in working with tenants is that it is better for your tenant if you send them a notice right away, but make that notice period longer. So instead of waiting a week or two to send them a formal pay or quit notice, go ahead and send that formal pay or quit notice as soon as your grace period expires. And you don't have to have a grace period by law. I know a lot of landlords do. And so tenants have automatically an extra 5 days. But I would suggest, on the 6th day, send them a notice saying, hey, you have 14 days, even though by law, as of July 1st, you only have to give 5. But if you have been the type of landlord or a landlord who has traditionally waited till the middle of the month to send a pay or quit anyway, I would suggest that you send the pay or quit earlier, but give that extra time after the notice goes out. I would also suggest that you keep in as much information as possible about how to access rent relief in that notice. You all have it in there now. You have the 14 days in there now. I'm sure the rent relief program may be running out of money, but you have some local programs that you'll hear about later that you could include in your pay or quit notice. I think that the more information, the more opportunity people have to get money to pay the rent, the better it is for everybody. So anyway, but the law says, that's what Christie says, the law says beginning July 1st, you only have to give a 5-day pay or quit again. And we've talked about the next dot. I think I've talked plenty about that. But then finally, if you are a landlord who has more than 4 rental units, and that can be 4 single-family homes, it can be 2 duplexes, it can be 1 building with 4 apartments, any of those things. If you have more than 4 rental units, you must offer your tenants a payment plan in addition to telling them about the rental assistance through rent relief and applying on their behalf. That again expires on July 1st. Okay. Now, this is an interesting thing that I don't think has gotten a lot of press, and so you may not have heard about this yet. But there was a law passed again during one of the special COVID sessions that is in effect for the next 6 years. So it's in effect for a while. It only applies to landlords who are bigger landlords and have more than 4 rental units. And it deals not with ending a tenancy for non-payment, but with whether or not you can deny somebody the right to be, or the opportunity to be a tenant because of a history of non-payment. And basically what it says is, if somebody has a history of non-payment of rent, or was evicted, or was sued in court for non-payment of rent during the pandemic, which is being defined as between March 12th, 2020 and July 1st, 2021, so last year, right? If somebody didn't pay their rent during that time, you cannot use that non-payment as a reason to deny their application for tenancy. There are other pieces to this. You do need to provide written notice of denial. How would you know, right? If it comes up, you're not initially responsible for going back to the third-party tenant screening company, if you're using one, and saying, hey, there's an eviction on here, or hey, there's some non-payment notes on here. Can you tell me more about that? You don't have to do that every time. What you have to do is, if you're going to deny somebody for non-payment of rent, you need to send them notice of that. And you need to say in your notice, you were denied because of non-payment of rent. And you must tell them, if that non-payment occurred between March 12th, 2020 and July 1st, 2021, then you have a right to challenge this. That notice also has to have the statewide legal aid phone number and website. It's a little bit confusing in terms of timing. If you are mailing the tenant the denial notice, they have 7 days from the date on which it was mailed to contact you and object. But if you are emailing or calling the tenant, they only have until the next business day. It's really important for you to note the deadline in your denial letter, because otherwise it's sort of a meaningless right to say, hey, you have the right to object to this, but I'm not going to tell you when you have to make your objection. Right, so that's that. Now we are actually getting into, so those were the laws that were temporary, right? And the notice and the 14-day pay or quit. So the special notice with all of those extra things in it, the 14-day pay or quit period, and the obligation of the landlord to apply for rental assistance for a tenant who's behind on rent, and the obligation of a landlord with more than 4 rental units to offer a tenant a payment plan if they're behind on rent. Those are all in effect today, but they won't be in effect on July 1st, right? So those are now, not later laws. Then you've got your prohibition on denying an applicant who didn't pay rent during COVID, March 2020 through June 2021. Those are now and later. That is a now and later law, because it's in effect until 2028. Now we're coming to the later laws, the laws that go into effect on July 1st of this year, but will remain in effect indefinitely unless and until they're changed. So I'm excited about these. These are the new, relatively new laws. Now, so, I'm sorry, and I apologize. We're first going to talk about the laws that went into effect July 1st of last year, which I'm also excited about, and then we'll get to the next one, to the newer laws. So these are actually now and later laws also. This is a remedy, the tenant's remedy for unlawful eviction. As you all know, there are rules regarding the procedure for evicting somebody for whatever the reason is. You have to give a notice, as we've been talking about, and you have to file a case called an unlawful detainer, or a case for eviction in your general district court that has to be served on the tenant. And then you have to go to court, and you have to get an order of eviction, and then you have to get a writ of eviction, and you have to hold on to that writ for 10 days until the expiration of the appeal period. And then you can arrange and schedule the eviction. You all know that. When you have to evict someone, I'm sure that's the process you use. But unfortunately, there are landlords who are not the professional landlords that you are. And we heard from more and more tenants in the beginning of the pandemic who had been forced out of their homes by unprofessional landlords who changed the locks, cut off the electricity or water, or took other action to put people out without sending notice and going to court. So this is a remedy for tenants who rent from those unprofessional landlords. If they are put out under one of those unlawful means, and the means are listed there, they can file what's called a petition, tenant's petition, or a petition against unlawful exclusion, I think is what it's called. And the tenant can file this, and it has to be heard fairly quickly. So it has to be heard within 5 days. I believe it's 5 days of when it's filed. Mark on the next slide. Yeah, okay. And then there has to be another hearing within the next 10 days. That part isn't new, nor is the fact that the court can order an unprofessional landlord who takes these actions to undo them, right? Put the electricity back on, let the person back in, etc. What is new is that the court can also award the tenant damages in the amount of $5,000 or 4 months' rent, whichever is more. So an unprofessional landlord who evicts somebody without going through the proper court process can be ordered to pay $5,000 or more to the tenant. So an important thing for you all to know, because I think that it is part of, I say, your responsibility, but it certainly is something that helps your profession even more if you help to police it, right? By knowing this law and knowing that if you hear about somebody taking this action, that you are able to say, hey, you know, you could be fined, not fined, but you could have to pay $5,000. So we're hoping that's a deterrent and that these unlawful evictions no longer occur. Okay, now we're on, no, we're not. This also is a now and later law. This law went into effect last July 1st, so it is effective now, and it will continue to be effective unless and until somebody, unless and until they change it. So this has to do with something called acceptance of rent with reservation. So for as long as I can remember, if a landlord has sent a pay or quit notice or filed a case in court against a tenant for non-payment, and then the tenant pays, the landlord is obligated to give a notice of reservation, which says, hey, I'm still gonna evict you. Until July 1st of last year, however, there really wasn't much guidance for landlords on what exactly that notice had to say. And so the Property Law Center worked with the Virginia Association of Realtors and some other property management groups to come up with some language that can be used that you all know will comply with the law. So first of all, and this is actually a just a clarification of something that was in effect even before July 1st, 2021. If a tenant pays everything that they owe at least 48 hours before the sheriff's eviction, the eviction cannot go forward. So what does that mean, everything they owe? Well, it depends on the point in time, right? So if it is between when the pay or quit was received and when the case goes to court, it's simply rent and late fees. If it's after the case goes to court, then it's rent, late fees, court costs, and assuming that there is a provision regarding attorney's fees in the lease, which most of you have in your leases, attorney's fees, that all has to be paid. If all of that is paid, the case is dismissed. Now, what happens if there's an order entered, there's a writ of eviction, you all obtain a writ of eviction, and you either are going to schedule the hearing once the 10 appeal days expire, or you already have, the eviction, or you already have scheduled the eviction. What then happens if the tenant pays, and what do they have to pay? Well, they have to pay, they have to pay all of the things I mentioned earlier, the rent, the total rent due, the late fees, the court costs, if appropriate, attorney's fees, but now they also have to pay the sheriff's fee. Well, how do they know that? Well, the law allows them, or what the law says is, if a tenant asks the landlord, hey, how much do I owe as of today? You are obligated to provide the amount owed. And if they make that payment in full, at least 48 hours before the eviction is scheduled, then you must cancel the eviction. It used to be the fact that tenants could only use this right once every 12 months. That is no longer the case. As of July 1st, 2021, tenants can use this right to pay everything they owe up until 48 hours before the eviction, as often as they need to, unless they're renting from a landlord with 4 or fewer rental units and the landlord has given notice that they only have the right to do this once every lease term. Now, again, that's what the law says. What Christie says is, why not let somebody do this as often as possible, and not as often as possible, as often as necessary, because because paying before the eviction is scheduled gets everything paid much more quickly in cases where you have to sue somebody than trying to collect it through some other means. So that is my suggestion, if you will. All right, moving on to the next slide. This also is now in later bill. It's in effect now, and it will be in effect indefinitely. And this has to do with damage insurance. So the law now allows tenants to pay for a damage insurance policy instead of a security deposit. It is at the tenant's request. I don't think there are many insurance companies offering this damage insurance. I think the main thing for you all to know is that the total of the premiums for the damage insurance, and if there is a security deposit, the security deposit can't be more than 2 months rent. Okay, this is probably a big deal down your way because I know that there are a lot of military folks down in your area, and I know that for many, many, many years, the standard lease that the Virginia Association of Realtors put on the internet that I would suspect a lot of landlords used, had a provision that waived, in which the tenant waived, or through which the tenant waived all of their rights under the Service Member Civil Relief Act. This was what we call a pre-dispute waiver, meaning they waived all their rights to contest any kind of lawsuit before the lawsuit was even filed. Well, you don't even know what it's about. You don't even know whether you want to waive things or not. And so in 2021, the General Assembly said, yeah, it doesn't make sense to waive something before you even know what it's about. So what this did was, it makes it unlawful for a residential lease to contain a provision through which the tenant waives their rights under the Service Member Civil Relief Act. Does that mean they can never waive their rights under the SCRA? No, it doesn't mean that at all. It means that if a service member is going to waive his or her rights in a landlord-tenant case under the Service Member Civil Relief Act, the biggest right of which is that you get an attorney, a guardian ad litem assigned for you, and you get to put up your case for 90 days. But let's say a service member couldn't pay the rent, knows that he couldn't pay the rent, getting ready to find a new place to live anyway, but has no defense. And in that case, they may decide that they're not going to waive, that they do want to waive their rights under the Service Member Civil Relief Act. For example, let's say a landlord says, look, if you pay me half of what you owe, I'll dismiss this case, but I want to do it now. You need to be out in 30 days and pay me what you owe within 30 days and I'll dismiss the case. But you have to waive your rights under the Service Member Civil Relief Act. Otherwise, we can't do this in 30 days. It will take 90. That sort of thing. Once you know what's going on and what you're getting as a benefit for waiving your rights. So that is a now and later law. So it's in effect now and it will remain in effect. Back in 2021, the General Assembly also added protections to the Virginia Fair Housing Law, making it unlawful to discriminate against military people in the provision of housing. All right, now we're getting into the stuff that doesn't go into effect until later. So first we did the now stuff, which won't be in effect for past July 1st. Then we did the now and later stuff, which went into effect July of 2021, is in effect now and remains in effect. Next few slides deal with only the later, which is these laws will become effective July 1st of this year, but then they'll stay in effect unless and until the General Assembly changes them. So one of the biggest changes that goes into effect in the landlord-tenant arena on July 1st of this year is that indigent tenants, so tenants who are poor, will no longer have to post an appeal bond to appeal an eviction based on non-payment of rent from general district to circuit court. Now, this is not everybody. Tenants who don't meet the requirements of being indigent will still have to post a money appeal bond. Now, how do you determine whether or not someone's indigent? The new law that goes into effect July 1st of this year says that for these eviction cases that are being appealed, the judge is going to look at the same criteria that she looks at to determine whether or not a criminal defendant is entitled to court-appointed counsel. So it's a pretty low or pretty high bar, I guess. It's not easy to meet the indigency bar. It really does require that you have very, very, very little money. All right. Now we're really in the now and later era. You all probably know all this. This is a big review, but just in case somebody's a new landlord, I wanted to go over some really important laws that passed before the pandemic hit, but became effective during the pandemic. So with so much going on, I know things may not have been as obvious or as focused on as they might otherwise have been. So first of all, the late fee cap. Until July 1st, 2020, you all could charge any amount of late fee that you put in the lease as long as the tenant agreed to it. Now, and since July 1st, 2020, and for the indefinite future, landlords can't charge more than 10% of the amount due and owed by the tenant as a late fee. Why does it say due and owed by the tenant? Well, that's really important for folks who are accepting housing choice voucher tenants, which is another thing we're going to talk about in a second. But if you have a housing choice voucher tenant, then you know that the amount owed by the tenant is not the total amount. It's not always the total amount due, right? Your housing authority or other authority, other voucher administrator is going to be paying the bulk, usually the bulk of the rent, not always, but usually the bulk of the rent. And then the tenant is going to pay an amount equal to 30% of her income. So the late fee can only be applied to the amount that the tenant has to pay. So if the entire amount of rent is $1,000 and the tenant pays $500, but the whole darn thing is late, I don't know why it would be, because one thing's coming from one source, one's coming from another. But let's say it is, you can't charge the tenant $100 in a late fee. You're limited to $50. Then finally, I mentioned earlier housing choice vouchers. Because of a law that became effective July 1st, 2020, and is still effective, you can't refuse to rent to someone just because they have a Section 8 voucher or just because they have a VASH voucher. Now, that doesn't mean that you have to accept every person who comes to you with a voucher. You can still do the standard background check that you're doing, and if they don't qualify under that background check, then you don't have to accept them. I will caution you though, in terms of income qualifications, one thing that we've seen landlords do that we think is a violation of this new law is not adjust their income qualifications based on the amount the tenant has to actually pay. So if I require that you make 3 times the rent amount and rent's $1,000, but you're only paying $500, I can't say, oh, you have less than $3,000 in monthly income, you're not eligible. No, but I can say, oh, you have less than $1,500. That's not going to happen because if it's a federal Section 8 voucher, it's going to be fine. Let's see. That is it. So we're ready. I hope that there are some questions. I hope there are some questions. I'm not sure where to go from here.
Yes, we do have a few questions that were entered in the question box, and anyone that's attending, if you have a question, go ahead and fill that in the question box so I will read it, or you can raise your hand and I can unmute your line so you can ask the question directly. But first, the questions we have, one is from Miss Vicky Hudson. She asked, giving for the 14-day notice is a problem with all money due as of the date of court when you only have 30 days to be in court, which causes monthly filings on tenants, which then charges them twice for the cost instead of one, as we are able to do. And so I don't know that this is exactly a question. It is a...
Well, I understand what she's saying. I'm not entirely sure why there's a requirement that you take someone to court within 30 days. That I'm not clear on. But what she's saying is, if you wait 14 days, then you would be filing later, and thus getting into court later. And so the amount due as of the court date will be greater, and the tenant will have to pay more as of the court date. And that's true. But I will remind you that to the extent that you can collect what is owed before filing, you're saving yourself and the tenant ultimately the cost of the court filing. So hopefully that addressed that issue.
Okay, thank you. And then we have a hand raised from a Miss Latanya Pratt. I am going to go ahead and unmute you. So if you unmute yourself and you can go ahead and ask your question directly.
Thank you. So my question was, okay, so you said that when it comes to acquiring or adding the late fee, if the rent is $1,000 and the tenant pays $500, we're only supposed to add a late fee to the difference. So that would be 10% of $500 left of what the rent is owed, but not the full. Is that what you meant?
I was only talking in terms of a voucher. So if the tenant is only responsible for paying $500 because the voucher pays the rest, then you can only charge the tenant 10% of the $500. If the tenant is responsible, but no, you're right. Actually, what you're saying is correct. If the tenant has to pay the whole thing, $1,000 $1,000 and the tenant pays 500, then you can only charge her the 10% on the 500 due. So
Okay.
either way, you're limited to the 10% of the 500.
Okay. And then when it comes to 3 times the rent, when it's based off of an individual that receives the voucher, we have to do 10% of what the client income, reported income is, or how much the voucher amount is. I'm confused on that part.
Sure. So in other words, what I have heard come up is that landlords often require, in order for a tenant to qualify, that they make 2 or 3, that their income is 2 to 3 times the amount of rent they would have to pay. And what I'm saying is when you look at the amount of rent that has to be paid, if it is somebody who has a voucher, you should only use the amount that the tenant pays herself. Does that make more sense?
Yes, it does. Thank you.
Thank you for that question. I'm sure.
Okay, no problem.
Thank you. We have another question that was submitted from Ms. Kirsten Hall. The question was, so after July, we only have 5 days, even if funds are available.
So after July, a landlord can give as few as 5 days to the tenant to make the rent payment late. So if I'm the landlord and my tenant hasn't paid by the 5th of April, this year, in April, I would give him a pay or quit notice that says you have 14 days to pay. You have to pay me by the 19th. That notice this year would also say, if you can't pay, here's the number for applying for rent relief, and I will apply for rent relief for you. Beginning July 1st, let's say same tenant doesn't pay me by the 5th, and I have a 5-day grace period. I don't have to send that notice that gives him 14 days. I can send a notice that gives him 5 days and say, look, if you don't pay me by the 10th, I'm going to take you to court. Did that clarify it?
I hope so. That was Ms. Kirsten Hall. So if it didn't and you have another question for that, if you can add it in the questions or raise your hand right now. And I don't see that hand raised, but I do have another question. Oh, she does have her hand raised. So I am going to go ahead and unmute your line, Ms. Hall, so you can go ahead and ask your question.
Hey, okay, thank you. So I guess maybe I worded it weird. So when you were speaking about the 5 days, you stated that even after July 1st, 2022, that we're hoping that there would still be funds available. So I guess even on, so July 1st, 2022, even if there are still funds available, we can still only do 5 days. We're not required to do the 14.
That is correct. Yes.
Okay, thank you.
Okay, we have more questions submitted. We have one from Miss Renisha Ricks. She would like to know, she's not sure if she missed the answer, but is there any guidance on how long it takes for the monies to be released after the application?
Unfortunately, no. And there have been problems with that as they switched over to a different system at the state level back in February, I want to say. I know things have slowed down and we've all been very frustrated by that. So there's no requirement on the part of the state. It's simply if the money isn't released to the landlord within 45 days of all of the documents being filed and the application being complete, then the landlord can take other action, like moving to evict the tenant.
Okay, and I think she had additional questions for that. So Ms. Ricks, I've unmuted your line. You can go ahead and ask directly.
Thank you. I just wanted to ask a question in regard to the application process. So I work for a project based as well as rapid rehousing. We work with both funding pools, and I find that a lot of landlords are utilizing like backdoors to avoid accepting our clients. So you spoke on the requirements for income. That's one way that a lot of people are avoiding accepting our programs, with the law being that they're supposed to be the source of income as a protected class. They are then saying, oh, they don't work at all, we can't accept them. Could you give any guidance on things like that so that we can kind of combat that?
Yes, so the first thing there, all of that gives rise to a cause of action. So those tenants who are being denied because they have not additional income sources, or who are being required to provide 2 to 3 times the full rent instead of the amount that they're obligated to pay, I think have cases under the Fair Housing Act source of income provision. And there are 2 ways to go there. They can file a case with the Fair Housing Office, an administrative case with the state, the Virginia Fair Housing Office. If the Virginia Fair Housing Office finds cause, which means there was probably a violation of the Fair Housing Act, then the Attorney General will actually file a case against the that provider, that housing provider, or they can file their own case. Now, all of that's pretty overwhelming for a tenant, so there are resources. Housing Opportunities Made Equal is a nonprofit that focuses on these fair housing cases, and in addition, a lot of the legal aid, so the legal aid that serves your area is Legal Aid Society of Eastern Virginia. They can also take these cases. I don't know if they are currently taking them, but they could. And finally, my organization, the Virginia Poverty Law Center, we are in the process of hiring an attorney specifically to deal with fair housing cases against landlords who violate the Fair Housing Act. So, that person will be working with attorneys all over the state to help them file cases. So hopefully that answered your question, but the place to start right now is Housing Opportunities Made Equal.
Okay, the next question we have was submitted by Miss Beth Brooker, and the question is, we have run into LL that say clients have to meet income requirements. What do we do when a landlord does that?
So landlords are allowed to have income requirements. It's how they use those income requirements that can violate the source of income law protection. So you have to do a little math, which I hate doing, and figure, the question is, are they, when they say, oh, this tenant isn't eligible because she doesn't meet the income requirements, have they used the full amount of the rent and compared 3 times the full amount of the rent to that tenant's actual income, or have they used the amount that that tenant has to pay, which would be a lot less if she's a voucher holder? But actually, actually saying you have to have a certain amount of income is not unlawful. What's unlawful is to treat people whose income comes from to treat people differently because their income comes from a particular source, like a voucher, or we've heard of landlords who simply said, well, I'm not going to accept any rental assistance. I'm not going to accept any government funds. They cannot do that without violating the Fair Housing Act.
Okay, thank you. We have another question submitted by Miss Vicky Hudson. She wants to know, Norfolk Court demands we do court date in 30 days. So I don't know if that's the
So,
question.
well, no, I understand, I understand her point there.
Okay.
There is a provision, a law that says that the court shall hear these landlord-tenant cases within, actually, I think it's within 15 days or as soon as possible. So they're just following the law. So the scheduling within 30 days is within the compliance with the law.
Okay. And we have a question online from Hudson Heinrich. I'm going to go ahead and unmute your line so you can go ahead and ask your question directly.
Okay, can you hear me?
Yes.
Okay, awesome. Thank you, by the way, for saying my last name right.
No problem.
Excuse me. I had a similar situation as the person who asked a question. I think it may have been like 2 questions ago. So I actually work at a housing program that provides subsidy payments for tenants. And a coworker of mine had an issue with a landlord locally where the subsidy payment for that applicant specifically would cover the entire rent amount. And therefore, the client, obviously didn't have any form of income. We were trying to get them on board with, whatever we could. But the landlord was saying that outside of the subsidy payment, that the applicant had to like be able to show they received at least $300 a month. And yeah, your response is kind of telling me what I need to hear.
Yeah, so I think that's a violation of, I think that's probably a violation of the source of income provision of the Fair Housing Act.
Okay, that's what I said to her too. I just wanted to make sure.
And that $300, that's like a made up number, right?
Exactly.
Like if somebody who had income came in, income from wages, came in and had whatever, 3 times the amount of the rent that had to be paid, it's like telling that person, oh yeah, but you have to have an extra $300 on top of that. I bet that landlord does. And that would be the equivalent. So I would refer that person to Housing Opportunities Made Equal. And just so you know, the Housing Opportunities Made Equal is going through a transition right now with their executive director. They have a new one coming on board. And so things, I always worry when that happens, no matter how good an organization is, that things might get lost in the shuffle. So if anybody tells you that they, it's been a week and they haven't heard back from them, whatever, do reach out to me and I'll see what I can do, because I have a number of contacts over there.
Awesome. Thank you so much.
My pleasure.
All right, thank you for that question. We have another one submitted from Ms. Shante Carter. The question is to confirm that we give them an additional 14 days after the 5-day grace period.
Yes, and the 5-day grace period is not required by law. I just know that a lot of landlords do that. And in fact, I think it might even be in the Virginia Association of Realtors model lease. So you don't have to give them a 5-day grace period as a landlord, but you do have to provide that 14-day pay or quit until July 1st. And then it becomes a 5-day pay.
Okay, thank you. We have another question submitted by Miss Elena Chambers. And the question is, she has been waiting for rent relief payments since January 30th, 2022. I'm sorry, 2022. And the question is, can we get a legislator involved to speed it up?
Worth a shot. The first thing I would ask, though, is, are you working with a rental assistance specialist? There are, sometimes they're called rental assistance navigators, sometimes rental assistance specialists. But Legal Aid Society of Eastern Virginia has a really good rental assistance specialist, and her whole job is to help people get rental assistance as quickly as possible through the state program. So if you have not reached out to Legal Aid Society of Eastern Virginia, that should be the first thing you do. I can tell you that many advocacy groups have made DHCD aware. They know that there are problems with how slowly things are going right now. So I mean, it never hurts to get a legislator involved. It could elevate your case to the top of the pile, but I would also call Legal Aid Society of Eastern Virginia.
Okay, thank you. And we have another question from Miss Kirsten Hall. Your hand is raised. I'm going to go ahead and unmute you, so you can go ahead and ask your question.
I am so sorry. I thought that my hand was unraised.
I
Oh,
do that all the time too.
I'm so
yeah,
sorry.
that happens all the time, no worries. Okay, so there's not a question there. We have a few more submitted questions. We have one from Miss Donna Jurgen, and she wants to know, how do the laws you reviewed apply to a tenant whose lease is expiring and not being renewed by the landlord? Are landlords now required to renew all leases?
No, we don't have that law. There are states that have something called a good cause eviction only law, in which case the landlord must renew a lease unless the tenant has violated some provision of the lease. We do not have that law. There is nothing in Virginia law that requires a landlord to renew a lease. Did that answer your question?
I believe so. I don't see her hand raised.
So there's one caveat to that. If you believe, based on things the landlord has said or done, that the real reason your lease isn't getting renewed is because the landlord doesn't want to deal with getting rental assistance from a governmental or other third party, that could be a violation of the source of income rule that we've been talking about. But unless you have evidence of that, it's really hard to prove.
Okay, thank you. And Ms. Durgan said that did answer her question. So thank you for that. We have one final question. So if there are any more questions, if you can go ahead and submit them in the question section or raise your hand. But the last one I have submitted is from Aaron Richett. And the question is, I have a rent relief question. The 45-day period is that after it is fully approved or once all documentation has been submitted and accepted and the application is in review. Or if we have not received the check within 45 days of approval.
Right, so it is completion, not approval.
Okay.
So it's within 45 days of when the application is complete. So it was your second option there, which was that all of the documentation has been submitted and it's seen as complete and is waiting for review.
Okay, thank you. And I have a question from Ms. Shante Carter, wants to know, are we able to get a copy of the slides? And actually, you do have a copy. A copy of the slides will be emailed to you, but they're available right in your GoToWebinar control panel. So it should be right there where it says handouts. You should have that available to you right now. But
And
we'll
I want to point out, and you see it on the screen right now, but please feel free to email me with any questions at any time. We're here to be a resource for the rental housing community. So happy to answer questions over email.
All right, thank you so much. And thank you for answering all these questions, Ms. Marra. And I'm going to hand this back over to Ms. Pointer.
Great, thank you so much for having me.
All right, thank you, Ms. Marra. For those of you who have additional questions, or some may arise later, please reach out to Ms. Marra directly using her contact information, which is provided on your screen. While we are here today, we do want the opportunity to introduce some additional programs to you, the Housing Choice Voucher Program and the Rent Ready Norfolk Program. So first, I'm going to start off by informing you about the Housing Choice Voucher Program, which is a a program that assists low-income households, including elderly and disabled individuals, to afford decent and sanitary housing in the private market. To join this program, there is no cost to landlords to participate. NRHA will advertise your property for free. Also, NRHA provides prompt, convenient, and free housing inspections. Housing assistance payments are directly deposited into landlords' account of their choice. And NRHA staff are here to assist with any needs of the landlords and the tenant, and also if any landlord-tenant issue may arise as well. There are many benefits to renting to a HCV participant. So I'll just list a few. Most of our HCV tenants live in their homes for 5+ years, so the turnover rate is low. Reliable income. Our participants are thoroughly vetted to ensure that they can afford their share of the rent. Also, they receive financial assistance from the Housing Authority, where the Housing Authority pays about 70% of their rental income, if necessary and needed at that time. We do have high quality tenants. We complete background checks when they're admitted to the program and every 3 years after. We do have free biannual property inspections. So rental properties are inspected every 2 years to ensure that the properties are up to quality and maintained per HUD quality standards. So we are asking that all landlords who have rental properties within the city of Norfolk rent through the Housing Choice Voucher Program. Rental income is guaranteed each month. As I said, units are advertised through NRHA using our website, nrha.us. If you are interested in becoming a Housing Choice Voucher landlord, please contact me directly. My contact information is also provided on the screen, Ayanna Pointer, and as I said before, I'm the HCV Landlord Liaison. Next, I would like to introduce Ms. Yolanda Williams, who is the Interim Program Manager for the Rent Ready Norfolk Program. Ms. Williams, the floor is yours.
Good afternoon. Thank you, Ayanna. Good afternoon, everyone. As Ayanna stated, I am the interim program manager for the Rent Ready Norfolk program. And the Rent Ready Norfolk program is basically a program designed to boost the number of viable residential rentals that we have in the city of Norfolk. And we have a few features that the Rent Ready Norfolk program includes, which is the Landlord and Property Manager Certification Program, which coincides with the Renting Smart Academy. It's a list of courses that you must take in order to certify your residents in the city of Norfolk under the program. So there's 4 core courses that you must take and 2 electives. And your certification is valid for a year once you become certified. After you take your courses, your resident has to be quality assessed by a code specialist. Upon completion and approval of the assessment, this is when your resident is 100% ready for certification in the city of Norfolk. We also have a tenant education video series that we will be launching in July. It's a series of short videos, maybe 2 to 3 minutes, that will educate the tenants on various topics as it pertains to renting. And then we have an incentive program, which is the Rental Resource Bank. And it's extended to landlords and property managers that allows them to advertise their properties on the Rent Ready Norfolk's website. That's just one of the incentives that we offer certified landlords and property managers. Thank you.
Thank you for that information, Ms. Williams. We would like to thank you all for joining us today. Again, a survey will be sent to your email by GoToWebinar. So we are asking that you take a moment to complete that survey to give us some feedback. Next month, we will have a session on April 26th. This session will focus on fair housing in light of the Fair Housing Month. So you'll learn about the trends and updates from fair housing. For more information, you can go to nrha.us using our event calendar. As I said, thank you for joining us today, and we hope you have a great day.